All right. Looks like we have quite a few people on. I'm sure a few more will join us shortly, so I think we can go ahead and get started here. Can everyone see my shared screen here?
Yep.
All right, awesome. Thank you. All right, well, good evening, everyone. Welcome to another Willamette Innovators Network Pub Talk. My name is Aaron Moore, and I'm a board member and president for WIN. If this is your first time joining one of our Pub Talks, WIN is a nonprofit member-supported organization dedicated to innovation and entrepreneurship throughout the Willamette Valley and Oregon. And our events are usually designed to bring people together. Of course, pandemic, so we're doing this virtually now. And our Pub Talk series focuses on providing insight into technology, innovations, as well as educational content geared towards you guys, our audience, entrepreneurs, innovators, and business owners alike. So I'd like to acknowledge and give a special thanks to our sponsors before we get started. Oregon State University, including the Advantage Accelerator and Research Office, College of Engineering, College of Ag, Eveshezky and Elliott, Corvallis-Benton County Economic Development Office, Oregon State Credit Union, HP Inc., and Ramsey Fab. Our sponsors help support our events and help us put these on. So thanks a lot to our sponsors for supporting us. If you're interested in becoming a supporting member or sponsor, you can check us out online at willametteinnovators.com, and you can also follow us there for upcoming events. I'd like to remind everyone that tonight's event is being streamed online, and the recording will be made available afterwards on social media. So if you have to leave or want to check it out later, you should be able to do that. And with that, I think we're good to move on to our topic for tonight, which is trademarks, copyrights, and IP. It is an area that I think impacts a lot of businesses that are starting up. They have a lot of questions, and we're very lucky to have our speakers tonight. I'd like to introduce Michelle Marie Rose from Bellwether Legal and Raymond Armentrout from More IP Law Solutions. And
Hey, everybody.
They will be presenting on the topics tonight. And I think they both have said that if you have questions during the presentation, to please speak up. So feel free to turn on your camera, ask a question. We do have about 30 people on. So hopefully we can kind of keep that civilized. And then we will have a Q&A session, hopefully after the two presentations. We were also hoping to have Eveshezky and Elliott, Jay Flint from there join us. Unfortunately, he had a conflict, so he's not able to be part of it. He will join us for more business-oriented legal questions at a future Pub Talk. So with that, I think I'm good to turn it over to Michelle. And if you have questions and don't want to come on video, you can always post it in the chat window, and we will try to get that asked for you. So, all right.
Hey,
Michelle, take it away.
here we go. Okay. Hi, everybody. I'm Michelle Rose. I'm the principal at Bellwether Legal in Eugene, and I'm very pleased to be here with you guys tonight. I have been doing trademark law for more than 20 years, but don't count and don't try to figure out my age because it's bad. So. But anyways, I've been doing this for a long time. It's my first love in the law. It's always been trademark. Copyright's close second. But this is my favorite thing that I do. Before I got to Oregon a couple of years ago, I was the chief trademark counsel at Whirlpool Corporation in the state of Michigan. So I'm originally a Midwesterner, relocated to Oregon, and enjoying my life way more now that I'm out here. So That's a good thing. Anyway, so I'm going to talk to you today about trademark and copyright. I'm going to leave the other forms of IP to my colleague, and we're going to take it from there. So these are my two categories. Clearly, I did not adjust this, right? My two categories are trademarks and copyright for tonight. So trademarks are your identity, like your name, like your own name of who you are, like, you know, my name, your name. That's kind of your trademark. But for a business, it's the identity of your business. It's a word, it could be a word, a name, a symbol, a shape, a sound, or any kind of combination of all these things. Here's some trademarks that you might recognize. These are a variety of designs, variety of words. Some have no words. You may not know that some of these are trademarks. I don't know if everybody knows that blue box with the white ribbon. That is a trademark owned by Tiffany and Company. Coca-Cola, the shape of the Coca-Cola bottle is a trademark. The shape of the Hershey's Kiss is a trademark. The UPS truck shape is a trademark. Here's some other ones that you'll recognize. A lot of online marks also you'll start to see. What's interesting about some of these marks is that up until 10 or 15 years ago, they didn't even exist. So that's what's always fascinating to me when I look at a montage like this. So I assume all of you know what all of those marks are. If you have any questions, you can let me know. Those should be pretty recognizable. I would also say that these are probably all very famous marks in the US and in many other countries. So then we get into the question of what is a registered trademark. So there's trademarks and there's registered trademarks. A registered trademark is a government grant that governments around the world can give you to prevent other people from using your mark in connection with your specific goods and services. All trademarks are registered with the federal government of each country, and in some cases, geographical regions. So for example, the European Union has a trademark office, so you can cover all, 27 countries now of the European Union with one trademark registration. In the real world where we all live, are there benefits to registration? And my answer is always yes. A trademark registration gives notice to the public of your claim of ownership of the mark. It's a legal presumption of ownership that is valid nationwide. It's the exclusive right to use the mark with goods and services in the registration. And if the mark is still in use between the 5th and 6th year after registration, it could be deemed incontestable. And that's a very valuable thing to have. That prevents a lot of people coming after you later and saying, oh, your mark is descriptive, or oh, your mark is this, and trying to cancel your mark. They would not be able to once you're deemed incontestable. So that's a very valuable thing to have. People always say, I've been using my name for 10 years, I've been using it for 15 years, why should I bother to file? Why should I bother to pay for a search? Why would I ever want to do this? It's a lot of money, it's a lot of time. And there's a couple of really good reasons why you'd want to do that. First thing is, if you haven't been using it and you're about to rename or name your business for the first time, you always want to do a check on the name, because there could be somebody out there with prior rights who could later stop you from using your name. If you guys saw the email today from Brad, you may have seen the link for the article about Holy Donuts and how they had to change their name here in Oregon. That's a great cautionary tale, if you will. The USA is a common law country, so with respect to trademarks, that means the first person to use a trademark has priority. So that's the other reason why you want to check, because if somebody else is using the mark before you, then you know not to adopt that mark as your company name or as your brand name. Again, the Holy Donut example is a great one. The other company had prior use by a number of years, so they were able to stop our local Oregon company. So if you don't know that there's somebody else out there that has taken your name already, or has used your name in the past, or has used it first, you have no way to know whether or not the mark is clear for your use and registration. So the key is always to know, right? To get somebody to do a search for you. You can do it yourself on the USPTO website. It's not very easy, but you can. But it's really important to always check your name first. A pretty big part of my business is from companies that have chosen a name without checking, and they get a cease and desist letter, and nobody likes that letter when they get it, and nobody wants to pay to have somebody answer it, and it's usually a pretty terrible thing. So it's always best to do the upfront work when you can. If you had a trademark registration certificate, this is what it would look like. So here's the best reason of all to go through the trademark search process and the filing. It is because searching and filing a trademark application and maintaining it over time costs far less than just the cost of one trademark allegation. And I use the word allegation because really when you get a cease and desist letter, somebody's alleging that you have infringed their mark. And maybe you have and maybe you haven't. But the point is it's an allegation that you then have to hire somebody to help you figure out whether or not you're in the wrong or they are. So the point is, there's no lawyer that is going to do that for very little money. It is always going to cost you far more to have to answer a cease and desist letter than it will to go through the trademark application process. Even though money's always tight early on in a business, it's still better to do it at that time to figure out how to make it happen and figure out how to make it work. Okay, there's the thing about the cease and desist letter. Okay, so when you're thinking about picking a trademark, there's a couple different levels of trademarks that you should know, and I want to help you understand how to pick a strong trademark, because there's strong trademarks out there and there's weak trademarks out there. The strongest trademarks out there are those that are fanciful, and fanciful generally means that they're coined or made up words like Kodak or Exxon. Those are coined terms. They have no meaning in the English language or any other language. They're just made up words, and those are the strongest possible trademarks out there. Then there's arbitrary terms, and those are the second most strong, and those are the ones where you take an ordinary word and apply it to a service or a product that is different than what the word means. So for example, Apple. Apple's one of the best examples of an arbitrary trademark. The fruit in Apple has absolutely nothing to do with computer services, phone services, has nothing to do with any of that, and that's why it's considered arbitrary. Similarly with Yahoo, similarly with Amazon. Those are common, ordinary English words that have nothing to do with the services or the goods that companies are selling under those marks. Is that if there's any questions, don't hesitate to stop me. The third level of strong trademarks is the suggestive mark, and those are marks that sort of suggest what you are doing. So like Greyhound for bus services, that's suggesting fast service. 7-Eleven. That's suggesting, the hours that a store could be open. The Mustang for cars, also suggestive of fast. So those are the three very well protectable trademarks out there. So fanciful, arbitrary, and suggestive. The best is fanciful, the second best is arbitrary, and suggestive is pretty good too, though not fantastic. Then once you get down to the descriptive marks, that's where you start being able to not protect your trademarks at all. So here's some examples of trademarks that were found descriptive. Park and Fly. You just have to look at that and you know exactly what that means, right? Vision Center and Computerland. Those are very descriptive. Now, sometimes you can gain what's called secondary meaning with those marks and still be able to register them because you've been using them for so long. You have millions of people that know your mark. You can prove this. You can prove how many millions of dollars you spend in advertising, and then maybe you can get that registered. But typically it's very hard. And then the very bottom is generic, and these words are not registrable. Ebook, Wi-Fi, and escalator. Escalator actually was a trademark, but the owners of the mark did not care for their mark, and everybody who started making moving staircases were calling their moving staircases escalators, so they lost their rights. Yo-yo is another example of a mark that was in the US and is no longer a registered trademark. They lost those rights. Aspirin is another one. Bayer owns the aspirin mark in most countries of the world, but the US they don't, because they lost control of that mark many, many years ago. So that's the levels of trademark, how to pick a strong one. I always recommend to people, do not pick a descriptive mark, or definitely not a generic. Do not pick a descriptive mark. It's too hard to try to get those registered, and you're far better picking a suggestive mark than a descriptive mark if you can't think of an arbitrary one or a fanciful
Michelle, I have a quick question, if I
Yeah.
can. Can you speak to a little in terms of trademarks with respect to like the difference between a logo and the name, and how that is treated differently, maybe, or the same? Or I mean, your trademark usually consists of maybe like for a business a name, but Apple has the Apple logo, which is different than the word Apple.
Yeah, let me go back to this. So if you look at this one, you'll see the mark. Let's take the top left corner, Coca-Cola, right? So that's Coca-Cola's logo, and that's what they use on most of their products. They also own the mark Coca-Cola in block letter format, right, which is just the word mark. So most people own, especially as companies get bigger and bigger, they own the word mark, like Coca-Cola, just in block letter format. They own the logo, and then they own variations on however many logos they normally use. So same thing for Harley Davidson and motorcycles. That's just one of the logos that Harley Davidson consistently uses. So in a company's portfolio, you can have hundreds of marks, even just in the United States, based on how you use them and what you use them for. So let's say this one is only on motorcycles, then they have a different Harley Davidson logo that goes on clothing, or they have a different logo that goes on, parts and accessories. So you want to protect both. And the bigger you get and the more famous you get, the more you're going to want to protect all the variations of the mark that you use. Did that answer your question?
It does. And then there's another question from the audience. What would my name be considered? I guess if you're using your own name as part of your business.
You can protect your name as part of your business, and you can register that. You'll have to sign a special form that says you as a person are giving permission to have your name owned as a registered trademark. But you can do that, and there are many examples of that, right? Throughout the business world, there's many examples of that.
And then I guess so. This is from Grateful Graphics. They're asking, what would my brand be considered? Their business name is Grateful Graphics. Graphics is spelled Graffix, so it's a unique spelling of it.
Yeah. So if that were me, I would file Grateful Graphics just as they have it, and that would probably be registrable. Sometimes if you have two words in your mark or more, like for example, this mark right here, this Harley Davidson motorcycles. So Harley Davidson is really the brand name, right? Motorcycles is a generic term that is on this. So in this logo, they have disclaimed motorcycles. And that means that they can't stop anybody else from using the term motorcycles in their logos or their trademarks. So this is a whole logo that they use, and they get protection for it, but they can never stop anybody else from using motorcycles, right? So the brand is Harley Davidson. So I would say in the case of Grateful Graphics, their whole brand name is Grateful Graphics.
Okay.
Especially because of that unique spelling. Okay, let me get back to where I was. Okay, so here's some examples that some of these I know of and I've worked on, and some of these I just can't help but show you. This is a store in Newport, Oregon, called Bed Bath & Beyond. Does everybody see why that's so problematic? It may ring a bell with Bed Bath & Beyond. I suspect Bed Bath & Beyond has never seen that sign or that store, so they've never gotten a letter. But if an employee from Bed Bath & Beyond ever did drive by that, they would tell their trademark counsel, and those people would get a letter. It's not usually a good idea to try to ride the coattails of a famous mark when you're picking a mark for yourself. Most big companies hate when you do that, and they will stop you. Here's another great example of that. This Starbucks case was a huge case. Starbucks sued Starbucks. I think in the end, Starbucks might have won, but it went on for, I don't know, some incredible a number of years. Drunken No Nuts, you really don't want to ever do something like that. North Face and South Butt, that was also a big case. That went on for years and years. North Face and South Butt. South Butt kept making more stuff. North Face kept trying to stop them. The South Butt must have had a lot of money because they kept, I think they were just trying to antagonize North Face. So Anyway, so when you're thinking about how to get started with the trademark application, it usually starts with a trademark search. So for me, I have a special database that I use where I get to look at all the trademarks in the United States. They're organized a little bit better than the database on the trademark office website itself. We run a search to try to determine whether or not the mark is available for use. Then I would send you, let's say if I was doing your work or somebody else, they would send you a clearance opinion that would say, yes, your mark is available, or no, your mark is not available. You, as the client, would then make your decision to file. You'd have to sign a power of attorney so that the attorney can do the work for you. And then when you file, this is a little bit interesting because sometimes the question is, should the business entity own the mark or should the person who owns the business own the mark? And that can kind of go either way. Sometimes I recommend that the person own it and then license the mark to the business. But most times I recommend that the entity own it. And that's why if you ever wanted to sell an entity or say you create a business and somebody wanted to buy it, all the intellectual property that went with that as part of the entity would go with the entity when it was sold. So any trademarks, patents, anything that the business owned would go with the sale to the new owners. There's two ways to file your mark, either under intent to use or already in use. If you have not yet used it, but you believe you will in the next 1 to 2 years, then I would say go ahead and file. If you're 3, 4, 5 years out from using it, I would say don't file because you're going to spend a lot of money while you wait to use it. Then you have to classify your goods and services. There's 45 different classes that the world has agreed upon. So we work on that, work on the description of goods and services. And then when you file an application based on use, you have to submit a specimen of use. So if you sell something through a website or you offer services through a website, we usually just use website screenshots, sorry. So that's what it takes to put together a trademark application. And then you go over the costs and then the attorney would file the application. And in the US now, so individual people, anybody who is a citizen of the US can file and take care of trademarks on their own in the US, but anybody who's outside the United States has to hire a US lawyer to help them with it. They can no longer go direct to the trademark office anymore, which is actually really good for trademark attorneys here. Okay, so once you decide on your trademark and you get it filed, now the question is, how do you use it? And consistent and clear use is the key. And I've probably said this 10,000 times in my career, consistent and clear use is the key. Because what you want to try to do is you want to develop an identity in your brand. You want to develop something that consumers will recognize and understand and know that that brand is connected to you. So for example, people always ask me about when do I use a TM, when do I use a Circle R? What I recommend is use the TM while the mark is pending and a Circle R after it is registered. Always use your trademark as an adjective along with a noun like Apple computer, a Sony camera, a Lazy Boy chair, or a Chevy truck. I should put Ford truck in there. I just bought a Ford truck. I should change that. Anyway, always use the legal line when possible, either on your goods or on your website, on your services. It should have a copyright indication. And then what I usually do is I call out the mark and I say, you know, for example, Google's registered trademark of, and then you put the owner of the mark right next to it. That also gives notice to the general public that you are claiming these words as trademarks. When you use your mark in text, I always use it in special typography, capitalized, underlined, italics, separated from the regular words of the text that you're using, and always try to avoid variations. Really, the best way to do consistent, clear use of your mark is to avoid variations on it.
Got a couple questions on your that and your previous slide.
Okay.
First question from Deborah Baker. How much should a new business budget for trademark registration? I think you had cost on the previous slide.
I would say, depending on how many goods and services they offer, I would say anywhere from $1,000 to $1,500. If you go with somebody reasonable, if you go to a big new downtown Manhattan firm, it's going to cost you $5,000. If you call somebody more local, it could cost you probably 1,000 to 1,500 at the most.
Okay. James Wagner says, what about symbols using common shapes such as the outline of a state?
If you use the outline of a state in your trademark application, you will have to disclaim that, meaning that it can be part of your logo, but you cannot claim exclusive rights in the outline of a state.
And Jason is asking, how long does the application process normally take, and how long does it take to get approval from the trademark office?
Depending on what attorney you use, they can probably get it registered. I can get something on the books and applied for usually within a week of my first contact with somebody.
Interesting.
The trademark office will then take about, pardon me? The trademark office will then take about 3 to 4 months until they take a first look at your application. And then once they do, they'll either approve it for the next step, or they'll send an office action and do a refusal. So,
and then
to get to a final registration, around a year to 18 months.
And then lastly, is it required to use the TM or the registered R symbol with your logo? Because there's a lot of, okay.
No.
Okay. I think that's it.
I have one question, if that's okay to jump in.
Sure.
Okay, it's easier than trying to type this out. I'm trying to go around getting an attorney for this and doing this on my own. One of the things I've run into is when I'm listing my different products. So I'm a glass blower and I'm making art products that are going to go out. Do I have to list all different products that go with this, or is it all the same, generally speaking, because it's the same material? Do you know what I mean? When
what you're making,
I guess it doesn't make sense.
What you're making again?
Yeah, so I'm a glass blower. I make art glass.
Okay, sorry.
And yes, yeah.
Okay.
Oh, sorry. So yeah, so I have multiple different products.
Right.
Okay. Okay, great.
Right.
So I don't have to do all the different sections.
No.
Perfect. Thank you.
Yep.
Okay.
Okay.
That's all I needed.
Okay. No? Okay. So now that you know everything about trademarks, I'm going to show you this photo that somebody put together a long time ago, and tell me what you think. So what this person did was they took the trademark for Crest and they put it on the trade dress or packaging of other companies. So that first one, you're probably thinking, hey, that's a Reese's peanut butter cup wrapper, but it says Crest on it. Or the second one is Kodak box, but it says Crest on it. And the point of this slide is to show you how consumers really learn and are taught what products look like. So for example, when I said clear and consistent use, you know that first one's a Reese's peanut butter cup because no other candy wrapper looks like that, right? You know that that's a Kodak box and nobody else has products that look like that. Same with the Hershey bar, the American Express card, the Lifesavers, the Camel cigarette box, and the Coca-Cola box. So you probably know all of those, what those products really are, even though they all say Crest on them, right? Yeah, I hope so. Okay, we're gonna assume you all said yes. But the point is, this is a great example of why clear and consistent use is important, because as long as you teach your clients and your customers what your brands are, they'll always recognize your brands, whether they recognize it through the shape or the shape of your package, the color of your package, any of your packaging, how you use your mark. You know, the thing about it is you want to be so clear and so consistent when you use it to teach people who you are. Okay, I'm just going to touch a little bit on copyright now. Copyright protects. Oh, any more questions on trademark? Let's make sure we've covered all that. Aaron, anything else coming in?
There was one question from Teresa. Says, so what about for a ranch? For example, we use, and I'm hoping I'm pronouncing this right. Strangle Bison Ranch. Would we just disclaim bison and ranch,
Yes.
or so you could only, it wouldn't be the whole name?
You file the whole name, files strangle, like strangling somebody around the neck. Is that what you said?
STR Stangle, STANGEL.
Okay.
Yeah.
So you file the whole name, Estango Bison Ranch, and then you would disclaim in your application bison and ranch. So you own the whole mark, but you cannot stop anybody else from using bison and ranch.
And then what about book titles? Are they trademarked?
No. The only way you can trademark a book title is if you have a series. So book titles like Harry Potter would be the series name, but the individual book titles are not protected under trademark at all. Actually, really, individual book titles are not protected at all, honestly.
All right, that's it for the questions that I have so far.
Okay, so that brings us to copyright. So these are the groups of works that are protected under the United States copyright law. Literary, so that's anything in writing, books, novels, short stories. Artistic works, that's everything. That's sculpture and paintings and everything you can imagine, glass blowing, all of that is all artistic work. Dramatic work, architecture, software, movies, music, product packaging, brochures, and printed materials. People don't often think of that, but all those are copyrightable, are all protected under copyright law. And your online content is all also protectable under copyright law. Copyright protection attaches to the creative work the moment that it's created and fixed in what's called a tangible form that is either perceptible directly or with the aid of a machine or device. So the moment that somebody runs a software program after they've invented it, because it's perceptible with the aid of a computer, it is fixed in a tangible form. Does that make sense? Does anybody have questions about that? No, okay. If your work is registered prior to when somebody infringes it, then you are eligible for statutory damages and attorney's fees if you sue successfully in federal court. Ariel, did you have a question?
Yeah, so I guess for mine, as opposed to trademarking or copywriting, I'm not so much concerned about, I'm not really looking to protect my artwork or the designs of my artwork. It's the name of the business. So I would still I would do a trademark, not a copyright, correct?
Right. Yes.
Okay,
Right.
thank you. Cool, thank you.
Okay. Okay, so if the registration occurs within 5 years of publication, it's considered prima facie evidence in a court of law. So if you write a book, if you write a screenplay, if you write, anything, copyright protection is very inexpensive. It's less than $100 to get something done, and you can just submit it through the Copyright Office. It's very, very inexpensive, and it's very, very useful. This might surprise you. Graffiti is protectable under copyright law. Just had a case with that. I never would have guessed that, but it is. So there you go. Okay. I want to do a little bit on licensing because I don't think this gets covered a lot in other forums. So licensing is about licensing usually your trademarks or your copyrighted material. Licensing is a huge business, and I haven't updated this number this year. These numbers run a couple years behind, but so in 2018, retail sales for licensed products were $271 billion. That's a huge, huge amount of money. And there's about a 3+ % year-over-year increase in prior years. Almost 80% of those licensed products are sold in brick and mortar retailers, and about 20% are sold to online retailers. That may be shifting a little bit. I'm not quite sure, but I'm sure during the pandemic, everything has shifted away from brick and mortar and into online. For many companies and brands, licensing has offered developers, retailers, and manufacturers a competitive advantage in the ever-changing retail landscape. here's a couple examples of licensed products. And you're going to see some of these, you're going to be like, oh yeah. So like, for example, movies in particular, affect kid shows. So those are a pair of Elmo slippers. There's SpongeBob. So these are really big licensors, right? Disney and the other major studios. You might not know that the U.S. Army is a licensor. They are. I'm not sure what they license, but they're a big licensor. Sesame Street, Warner Brothers, Nickelodeon, Nautica. So anyway, so these are just a few of the bigger licensors. Here's some of the products that you might recognize. So when you make a Klondike bar, if you want to put Heath bar pieces into your Klondike bar, you get a license from Hershey. If you're Breyers and you want to put Heath bar pieces into your ice cream, you get a license from Hershey, et cetera, et cetera. You get where I'm going with that. Hershey is a huge licensor. And these are called ingredient. When it's food like this, it's called ingredient license. Reese's ice cream cakes, those are really good, by the way. So licensing is huge when your market's big so that it's recognizable. Licensing is a great way to develop another source of revenue. And that goes for patent licensing too. There's also patent licensing. So trademark, copyright, and patent licensing. So that's my spiel. Unless anybody else has any questions.
I had a quick question on that last slide. And maybe this is more in general. When are you allowed to use someone's logo, or like, for example, in tonight's presentations, you've posted these logos and you didn't license them. What is considered like fair use, or when are you allowed to display someone else's logo? Like, for example, in the case of the Klondike bar, they're using that ingredient, whether they licensed it or not. Like, that ingredient is in their thing. What
Right.
permits...
So for Klondike, they would not put out a product without licensing that Heath mark and buying the little pieces of Heath bar from Hershey, right? I'm using this as in an educational forum. So in my mind, I consider this fair use because it's educational. But for products or services, there's no such thing generally as fair use. I mean, every once in a while there is. Like, let's say you make bicycle seats and you want to say, oh, my bike seat fits Trek bikes, or my bike seat fits Huffy bikes. You're going to be able to say your bike seat fits all these different companies, but you can't use their logos, you can't use their photos, you have to take your own, stuff like that. And maybe you do get a permission or a license from those bicycle companies, but the main point is you can say compatible with, you can say fits with, you can say all that kind of stuff.
So that would be considered fair use
too, right? Huh?
That would be considered fair use.
Yeah. So let's say you make auto parts for Chevy trucks. Okay. You can say these shock absorbers fit with Chevy trucks, these models in these years. You can say that.
Okay.
Without a license from GM to do that.
Two other questions. How important is a design mark? Is registering in special form better than standard?
I always say that you get the most protection if you register a block letter mark, because when you register a block letter mark, you can use it in any way that you can think of, and it's all constitutes actual use. If you have a logo, let's say you use it for 5 years, and the next 5 years you change it because you're tired of the first logo, then you have a hard time if you haven't registered that new logo, and it won't count for use of the old logo. So block letter is the best if you can get it. If you can't get it, you can only get your mark with a design, then get your mark with a design. That's better than nothing.
And then Grateful Graphics says, isn't parody okay to use adaptations of a company's trademark?
That's a good question. Parody has been found to be okay in a couple different cases. Hoot Diggity Dog is a very famous case where they were making dog toys, but they were using famous designers like Chewy Vuitton. There's a couple other ones they were doing. But anyways, parody has been acceptable in the court of law, but I'll tell you, you'll probably get sued. Even if the company is going to lose, they're still going to sue you to try to make you stop.
How does a service mark fit into this mix?
the exact same way.
Okay. And what is the process for registering a copyrighted work?
You can get on the US copyright website. It's copyright.gov. And there's a link for register my copyright, and you just follow the process through that and do a payment. At the end of it, upload your the product of what you want to copyright, and then upload it, and then you'll get a copyright registration certificate by email.
Okay.
You can register, actually, if you're a photographer, you can register up to 750 photos at one time now. For one price.
In the beginning, you mentioned that USA has common law. So to what degree would your own works be your own without having to go and pay and file for copyright?
They are still your own, but if you were to pay and get a copyright registration, if anybody ripped you off later, you would qualify for statutory damages and attorney fees back. If you don't believe that anybody's ever going to rip off your stuff, then you don't have to file a copyright application on it.
And then, since I am in this category, what if you are a business that didn't trademark and wants a trademark, and after the fact, what's some advice that you would have for companies?
What do you mean after the fact?
Well, so I've been running my business for several years, haven't trademarked yet. What should we do?
I think we should still do a search. In fact, that's what I do recommend for people who have been running businesses, because you want to know if anybody else has filed your mark in front of you, right? Because you may not know. Always start with a search, no matter what, and then see what's out there, see what the landscape looks like. And then once you see that, if you're still clear, then you can go ahead and file your mark. What's interesting is that some people have found when they go to file their mark, somebody who started after them has filed before them. This can get really confusing. So let's say you started using your mark 5 years ago. Let's say 2 years ago, somebody else started using the same mark for the same business, but they filed 2 years ago. So now the question for you is, what do? Right? Do you write to them and say, hey, you can't have your mark anymore, I'm going to file and cancel your mark? Or are you going to say, you're infringing my mark, you have to stop right now? It gets very complicated and it gets very expensive. So it's a risk, right? It's a risk. And I've had a couple of those recently where that's happened, and it's a risk.
And just out of curiosity, what is the recourse for having been using a name under sort of that, you said common law, and where you can prove that, but someone else registers it? How does that work?
Well, it depends on how much money you want to spend, right? Do you want to write a letter to the company and say, hey, we have prior rights, we're going to cancel your mark if you don't, voluntarily give it up? And if they say take a hike, then you can say, okay, you decided there you want to sue them because you want to keep using your mark. But now that you've brought yourself to their attention, the question is, even before you send the letters, do you want them to know about you? Because once they know about you, then they can turn around and say, hey, we've got a registration before you. Now, they're not going to win, though, because you're first to use. So it gets complicated and it gets expensive.
Okay. All right.
It really is a case-by-case situation, because unfortunately, there's no blanket answer for all of this stuff.
And what would constitute, I guess, date of use? Is it when you registered the business, when you what is first? So
what I use, when you register the business, is kind of your date of first use. Technically, there's 2 dates you have to put on your application. One is date of first use. That's kind of when you thought of the name and did something to solidify your use of it. And that's registering your business name. Then the second thing is, when did you launch your products? That's the date of first use in commerce. So let's say you are selling whatever shoes, right? And you registered your business name in January, and in June, you put up your website and you started selling your shoes on June 1st. Your June 1st date would be your date of first use in commerce. Your January 1st date would be your date of first use.
Awesome. There are a few more questions, but I think we can come back around during afterwards. So I can hand it over to Ray. And thank you very much. And Ray, I will pull up your slides here. Give me one moment. And in the meantime, if anyone has questions, please keep posting them. And then after Ray's presentation, we will have hopefully a QA session where we can address a few more of these. So Ray.
Great. Hey, all. Hi, I'm Ray. I'm going to share with you some information about what patents are from the perspective of your viewpoint, I hope, in that if you have something you think is an invention, well, what can I do to protect it? However, before I start that, I wonder, Michelle, am I going to get in trouble using this USPTO slide presentation? What I did was I went over to the patent website. It has tons and tons and tons of good information. And
I think you're going to be fine, Ray. I think you're going to be fine.
I took this nice slide presentation and tossed out a lot of the slides that really weren't relevant to somebody that's starting up a business and is thinking about getting a patent. I threw a couple in myself.
I call it fair use if I were you.
Fair use, good.
There you go.
What I urge you to do is, if you are thinking about getting into the patent process, please go to the patent website and look around and learn about this process. It's good for you because when you have a chance to talk with the patent attorney you're going to be working with, you'll understand a lot more of the conversation. Makes my job 10,000 times easier. So the U.S. Patent and Trademark Office has a lot of great resources, and as with the rest of the internet, tons and tons of articles and blogs, and on and on and on it goes. So I would encourage you, if you decide to go down this path, please bootstrap yourself up and get an understanding of this landscape, because it is very complex, very complicated, and everybody's needs are different. Nobody has the same intellectual property patent portfolio strategy. They're all different. Next slide would be great. So this whole patent business really goes back to day one for all practical purposes. And it's in our Constitution from the get-go. Next slide. What a patent does is, for your invention, it gives you the right to exclude others from making, using, selling, offering for sale, importing, or use of your claimed invention that you get a granted patent for. If you will, and pardon me for saying this, going to the patent office to get a patent for your invention is a little bit like a handshake with the devil. In exchange for you telling the world about your invention, how to make, use, and practice it without undue experimentation, that is, I'm going to tell the world, in return for that, you get a 20-year exclusivity period measured from the filing date of your application. So if it takes 3 or 4 years to get your patent granted, then you've got 17 years of patent protection, maybe a little more if they make some adjustments. The other important point is that a US patent only gives you protection in the United States, not in the worldwide, but I will briefly touch on that in a second. So next. This is me. One of the important aspects of you getting into this business of trying to get a patent application for your invention is finding a patent attorney that works for you. Not all patent attorneys are going to be a good match, and it's so important that you find somebody that is a good fit for your needs. So for me, I'm an electrical engineer. I was an electrical engineer for 20 years before going back to law school. And I've been working with a lot of high-tech clients. If you've got an invention for, say, and improved pooper scooper, I may not be the best person for that. And I use that as an example because actually my boss at More IP gave me an office action job where I had to work with one of those. And I was actually able to get a patent approved with patent office for this, but I wouldn't have been the best guy to write the patent application. So what I would urge you to do is, as you start to get into this process, talk to a lot of different patent attorneys, see what their philosophies are, see what their backgrounds are, see how they view things. I've worked with some startups, and so I'm very conscientious of cash flow management problems for a startup. On the other hand, I've worked for some really big dogs, and their annual patent budgets were $10 million, $20 million, $100 million a year. So what you want to do is find somebody that fits your needs. You might not need a full service large patent firm to help you with all sorts of business aspects. Maybe you just need somebody to do your patent application. And so a smaller, less expensive firm might be better than the full service firm. I don't know the answer, but I guarantee every single one of you out there is going to be in a different situation. So the first place I would recommend starting is after going to the patent office and other places and learning about the process of getting a patent, is finding somebody that matches your particular needs. Everybody's different. Next one. Next slide. So the US patent only protects you in the United States. There is this treaty out there called the Patent Cooperation Treaty, and literally most countries in the world have signed on to the PCT treaty. And the deal is picture the PCT organization as a large parking lot. You get your patent application prepared. If you give it to them, it's like you could park your patent application in the parking lot for 30 months, or sometimes 31 months, depends on the country. And within that 30-month time period, you have the right to drive out of the parking garage and file your application in any country that you're interested in. And the way we do that, say if I was working for you, is you might say, hey, I want to file my patent application in Canada. I go, okay, great. So I get on the phone, call up the Canadian patent attorney. I can't file stuff in Canada because I'm not registered to practice in Canada. And I say, hey, please file this application with the Canadian Patent Office. And the associate will get back to me and say, well, the Canadian Patent Office wants X dollars for filing fees. Our service for providing that filing of the application and all of that stuff will be a certain amount of money. And then, of course, our firm would have a little bit too. So that's Canada. And then Europe, China, Israel, and I've worked in all of these places, Japan, Indonesia, Australia. What I wanted to give you a sense is that the cost of this becomes geometrically out of control, geometrically expensive, hugely, hugely, hugely expensive. So you might say to yourself, well, maybe because I'm just working in the US, that's my market, maybe I'm not interested in international protection. And you would be absolutely right. Except, however, before we get to the except, one of the things about the PCT application is there's sort of a 1-year grace period. So when you file an application in the United States, be it a provisional or a non-provisional utility application, which we'll get to in a few minutes, you have a 1-year clock to think about whether or not you want to file that PCT application with the Patent Cooperation Treaty Receiving Office. Now, your 30-month period is already ticked away, so that leaves you, what, like about 1.5 years if you wait the year, but still, nonetheless, you don't have, you got a little time. I mean, maybe you want to test the waters. Maybe you want to see if your product goes crazy and that it is likely to sell across the world. However, many applicants have a business plan that involves ultimately selling their business or licensing their patent. So when you approach, say you come up with a new feature for a phone. So when you go to Nokia, if you go to them with a US patent that's been granted, well, they're going to do evaluation. They'll call out their cadre of patent attorneys and business analysts, and they will figure out what that patent is worth. If you have filed a continuation in the United States before you got your patent, then, and we'll get to that in a little bit, they have the flexibility of filing yet another continuation. So they might look at your patent application and go, well, you know, we might not have done the claims exactly the way you did them. We would have preferred to do it this way. Well, if that door is still open, then they can file a continuing US patent application with the claims they're really interested in. So when they go to evaluate you and figure out how much they're willing to pay, you can appreciate that having that flexibility for them makes you more valuable to them. And the same thing with a PCT application, because you go to Nokia, who spends probably $50 million a year on their IP portfolio management, they are going to look at you and think, wow, I've got 10 months left to get this application filed in 100 different countries where we're really interested in getting your patent application filed. So food for thought. When you get into this process and you're getting protection in the United States, you need to think about whether or not you want to get international protection for yourself, for your company, but also potentially for anybody you might be doing business with down the road, a partner, an investor, and a buyer. So just food for thought. I can't give you an answer what you should do because everybody's going to be in a different situation. Next slide. So there's basically 3 types of patents in the United States. I primarily focus on utility, but there is also a design and also plant patents. In the United States and across the world, there's certain areas, certain subject matter areas that are not patentable. Okay, so an equation is not patentable. You can't get a patent for an equation. Einstein was out of luck from the get-go. Plants and naturally occurring organisms sort of fall into that category too. You know, you trek through the Amazon, you find a new plant. No, you can't get a patent on it. However, the US has recognized that in some situations, somebody has created a plant. And if it's done in a certain way, it might be eligible for protection. So I was recently chatting with a guy over on the east side of the mountains in Washington, and the gentleman had figured out a way to graft, create a cherry tree where the cherries were ripe about 2 weeks earlier than any of the other cherries. And so he was able to get a plant patent for that. So it's a limited, narrow focus sort of situation where you might be eligible to get a plant patent. Now, plot back to finding the person that is a good match to help you get the patent you're interested in. Please do not come to me to ask for a plant patent. I just have no clue. The second kind is a design patent. Now, a design patent protects the ornamental look and feel of an object. I often tell people I'm chatting about this topic to picture a wrought iron worker in New Orleans who has come up with a new wrought iron railing for a balcony, a new design. And so we could draw up that new design for the wrought iron railing and get a design patent for that. That design patent only protects the ornamental look. There can be no utility or function, no purpose other than the pure ornamental design. Is it easy to infringe? Well, incredibly easy, because you can take a look at it, change one aspect of the design, and you're not infringing. But in many cases, a design patent is a good idea. And they're not horribly expensive either. You can get your foot in the door and at least get some level of protection for the ornamental look of your product. And this is not the same kind of protection that comes from the trademarks either. A utility application is directed towards the function, the utility, the use of an invention. So that is really the most common area of patent work that you'll find you're going to be interested in. If you have an invention, what we do is we write a patent application that describes your invention, but also the function, the utility, and the purpose of it. So those are the three types: utility, design, and plant. Next slide. So there's a couple things to know. This is so important. There are, you have an invention, you have an idea, and the last thing you want to do is take your idea and release it into the public domain, because once you do that, you don't get it back. So it's important to avoid public disclosure. Also, you can't sell your invention to somebody or even offer to sell your invention to somebody. And that somebody doesn't even have to know your invention's in the gizmo you're offering to sell them. In many countries, either of those events can cause an absolute bar to getting a patent in that country, because you've donated your invention into the public domain. Unintentionally, but you did it. In the US, we have a 1-year grace period in these two situations. And the government, the United States government, recognizes that, stuff happens, and often inadvertently. Now, non-disclosure agreements should be in place, but really the best practice is to get your application, either a provisional or a non-provisional utility application, on file first, because you can't let the cat out of the bag and get in trouble. And also, you're for sure protecting any potential international applications that might be filed. This has happened to me many times, and for instance, a war story, I suppose, would be I was working with some rocket ship guys who had come up with, their thing was this compression of plasma fields using magnetic fields and creating rocket propulsion. They had presented an IEEE paper, Institute of Electrical and Electronic Engineers paper. And they had then came to us and said, hey, we want to get a patent for our invention. Well, it had been over a year since they presented that IEEE paper. Well, it was a real problem. What we were able to do, though, was focus on the improvements that they had made. And we were able to get them some really good patent protection, but they let the cat out of the bag and they didn't get it done within the first year. So we lost, the real broad patent protection that we could have otherwise had. Now, this public disclosure can be any public disclosure. It can be you having dinner with friends at a restaurant. That's a public disclosure. You let the cat out of the bag. Well, how does this come to bite you? The patent office isn't ever going to know there was a public disclosure. Unless it was like a scientific paper or something, they'll find that. But if you were sitting around the restaurant and chatting with your neighbors and you tell them all about your invention and that's a public disclosure, how would that ever get you in trouble? Because the patent office isn't ever going to know. Well, what might happen is you get your patent from the patent office, you find an infringer, you drag them into court, you're going to sue them. Well, the first thing that happens is they go through the claims of your patent, and we'll cover that in a second, to try and figure out if they're actually an infringer. If they don't infringe, it's all over. They don't infringe. Game over, done. But if they are an infringer, they have to go to game plan 2. Well, game plan 2 might be to sit down and work out a deal with you, license, pay up, whatever. Or game plan 2 might be to do something to invalidate your patent. Well, what would happen if they found out about your friends that you were having dinner with and got them up in front of that judge and got them to sit down in that chair and tell the story? If you didn't meet the 1-year grace period, I think the judge would be very inclined to invalidate your patent. So please just avoid public disclosure and don't try and sell the thing. Go get your patent application on file first, because now you're protected and you can do anything. Next slide. So there's 2 types of applications in the United States, not all countries. In fact, I'm not even sure, I'm not aware of any countries that have the provisional utility patent application. The provisional utility patent application is an informal application. It's not examined or published, doesn't have to have claims, it has a 1-year lifespan. The non-provisional utility application is the formal application. It has 3 parts: the drawings, the disclosure, and the claims. We'll talk about that in a second. And it can claim priority to the filing date of the provisional application. This is their slide. Or is this my slide? Yeah, this is my slide. So when the examination process starts and you file your real deal application, your non-provisional utility application with the patent office, it gets assigned to an examiner and it goes into the examiner's in basket and it sits there. That examiner has got work all the way through their in basket before they can pick up your application and begin the examination process. And the only thing the examiner is interested in is whether or not you're first with your idea, first in the whole world with your idea. The examiner looks backwards in time based on the filing date of your application and then checks granted patents applications in the US, worldwide, checks scientific papers, checks for businesses, checks for websites, kind of checks everything to see if you're first with your idea. If you're first, you get a patent, you're an inventor. If somebody else was ahead of you, then they're the inventor. Even if you came up with your idea later on your own without any knowledge of what they had done before you, you're still not the inventor. They are. So the non-provisional utility application, the one that's examined, when that examination process starts, the examiner uses that filing date to start looking backwards in time, unless you filed a provisional application. If you filed a provisional application, the examiner uses that earlier filed examination date for the examination process. So it's a way for you to get your flag stuck in the ground and establish that filing date. Since they're informal, they can be done very quickly and they're less expensive. Often you would use one if there's some urgency. All this COVID stuff that's going on, I'll tell you what, it's a horse race right now to the patent office. So getting something filed as quickly as possible, it can be very important. Maybe an applicant wants to test the marketplace and see whether or not it's worth their trouble to pay for the more expensive non-provisional utility application at a later date. The provisional utility patent application also protects against public disclosure and that offer to sell bars. It also allows you to mark your product patent pending. Now, there's some disadvantages. Principally, it costs a little bit more. You'll pay for the cost of the preparation and filing of the provisional application. And then within that next year, you'll be having to also pay for the cost of the non-provisional application. So, if there's not any rush, if there's no urgency, if the cat's still in the bag and you're not racing against a time clock, why spend the money? Maybe it's okay to just go straight ahead with the real deal application. Again, I don't know. Every one of you will be in a different situation. Another disadvantage, potentially, is that if we file your provisional patent application tomorrow, and then a year from now, we file the real deal application, it gets into the examiner's in basket a year from now. And examination doesn't commence until a year later than it otherwise would. It shoves the whole process back by a year. Some applicants want their patent application in hand as quickly as they can. Maybe it's important for them to get that patent right away because they need to go out and raise capital or sell to a large company or something. I don't know what the answer is, but potentially that's another delay. So what's the takeaway here is be aware that there's a couple different ways you can go in the United States and learn about these, because when you're sitting down chatting with your patent attorney who's going to help you navigate this patent landscape, having an understanding of what your options are will help you and your attorney figure out the IP portfolio strategy that really works best for you. So the next slide. The next slide is, okay, this is the anatomy of the non-provisional patent that's finally granted. And this is the first cover sheet, the first page of your patent. And it has, like the name, it has the inventors are named, any assignees. It identifies the filing date. It also identifies any priority dates or any prior art references that the examiner considered. And then it has you get to pick a characteristic drawing that goes on the cover page. You get to pick one. Usually it's the first one. The abstract is simply a short summary of the invention. Okay, the written description, which follows after this, describes your invention. The drawings are formal drawings that illustrate your invention. The written description describes your invention in the context of those drawings, and also describing the use, the purpose, the function, that is the utility. And then we finally get down to the claims, and the claims define the legal scope of your invention. I often tell applicants that if you own a house and you want to know where the property boundaries of your house are, you'll go ahead and bring out the surveyors and they'll do their thing. And then you will get that legal description of your property. It'll say, you know, the northwest corner of your property begins in range X, township Y, and blah, 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 you know, on and on and on it goes. And that's the legal description of your property. The claims granted by the Patent Office are the protection that defines the legal boundaries of your invention. I think the next slide will have some, let's take a look at that. A sample claim. So a chair comprising a seat, a back support arms attached to the seat and back, and a base comprising a plurality of legs attached to the seat. So that's kind of the claim structure. The back, the seat, the support, the base, those are the elements of the invention. Notice that this claim, which is an apparatus claim, a structure claim, doesn't talk about any benefit, any utility, any purpose. It's just reciting the individual pieces to the invention. When you are filing and preparing a patent application and you get it filed with the Patent Office and the examiner starts to undertake the examination process, that examiner is going to be looking only at your claims and answering the question whether or not these claims define an invention. Is there something in one of these claim elements that you're first with? And that is the crux of the whole examination process. And they've got some more slides here in a little bit. I guess, yeah, we can go to the next slide. Let's go to the next slide and see what it is. So in the United States, only people can be an inventor. Now, it's really important that we get this right, because there's the question of who is the inventor, and if you don't get it right, what's the penalty? Well, the penalty is potentially revocation of your patent. It gets very tricky. What you want to do is, if there's multiple people involved in a project, we have to look at what each person contributed to the product. And I think maybe the easiest way to think about it is the gee whiz of the invention. If somebody contributed to a part of the gee whiz of the invention, then it's very likely they could be an inventor. If it is a situation where it's a person that is just working under your direction to build the invention, say it's a program coder doing the coding, they're not an inventor. If it's the machinist who is milling the parts to your invention, they're not an inventor. So we can't list them on the patent as being inventors. Another potential area where we've had problems are supervisors and managers. As supervisors and managers of an engineering group might want to have their name on a patent. Well, if they didn't contribute to the invention, you can't, no matter how much they want to, they can't say, hey, I'm the boss, I want my name listed as an inventor. No, you can't do that. So if you have workers working for you and they come up with an idea and you didn't contribute to any of the gee whiz, that's okay. we just got to be sure we don't list you as an inventor. What we do is we assign the invention to you, we assign the invention to your company so that you have the legal rights to it. We just don't want to list you as an inventor. Because again, if you make this mistake, that's fraud on the patent office. And the penalty is, of course, not very pretty.
Hey, Ray,
Yeah.
that doesn't include, you can list someone on a patent as a non-inventor, correct?
No, not as an inventor.
No, as a non-inventor.
No, that there's no provisions for that. Now, they would be, if they're the assignee, they would be listed as the assignee. So you would have the inventors, and then below it, you would have the assignee listed, like Hewlett Packard Company, or the name of your company, or even your name. But only if you own the rights to the patent, not the inventors. In the United States, the inventors, if there's multiple inventors, owns an undivided interest in the patent. So if there's two of them, one of the inventors can go out and sell that patent to the other, to a company or something, without anybody's permission, because they're an inventor and they own the patent just as much as the other co-inventors. So what's important here is that we get it right, and that we do the assignment of the rights to the invention to the owners. And so if you have a company, then, and you're the owners, then that's how we protect your invention. We get that assignment over to you. Does that make sense? Let's see, there is anything else about inventorship? There's a lot of things going on in inventorship, but we don't need to cover them now. It's let's just move on to the next one, because what I want to do is give you the broad overview from your perspective of what you might want to do if you think you have an invention. So what is patentable? Well, processes are patentable, machines are patentable, a composition of matter, and then an article of manufacture. So I guess in a nutshell, the patent office prefers to give patents to things they can hold in their hands, gizmos they can hold in their hand. However, we know in this electronic age that that's not always practical. And so processes have to be patentable. Otherwise, you know, there wouldn't be the internet, there wouldn't be cell phones, there wouldn't be apps. Certain areas, subject matter areas, are excluded from patentability. As we mentioned before, natural plants and animals, but there are other things, the equation, but also business methods and abstract ideas. These are two of the newer areas that the Supreme Court has concluded that these ideas are not patentable subject matter. I think the business methods problem started coming about back in the day when computers were becoming sophisticated enough that the stock industry, the traders, were able to develop all of these algorithms to project stock movements. And they started this process of filing patent applications and getting patents to these business methods of doing business. And it got to a point where the Supreme Court said, no. And then recently they took it the next step and said, you got to have more than an abstract idea. A business method is an abstract idea, but there's all sorts of things that are abstract ideas. which takes us back to this process problem. If you have an app, if you're developing an app, it's an abstract idea. It's just an abstract idea of how you're going to do business. But it's also not fair that you can't get patent protection for it. So what do? How do we skin that cat? Well, the way we skin it is we take a general purpose computing machine, be it a cell phone, a PC, or whatever, and we add your invention into it and transform that general purpose computer into a special purpose computer. And now you can get a patent protection for your special purpose computer because it has your software invention in it. So it goes all the way back up to one of the very first slides we talked about. When you have got an invention, it's important to find the right person to work with. I would be very good for this situation. I might not be so good for a composition of matter. I'd be probably pretty good for an article of manufacture. I could do machines. However, a mechanical engineer might be a better patent attorney to be working with. Again, every situation is going to be different. Oh, by the way, just to let you know, anybody that is registered to practice patent practice before the United States Patent and Trademark Office has to have a scientific background. So I'm an electrical engineer, computer science majors. You have to cross that threshold before you even are allowed to take and sit for the patent bar, the test that lets you become a patent attorney. So when you're going through this process of trying to find who you want to work for, you want to look into that background that they have, their technical background. Let's try the next slide. So the patent office here is telling you how much you have to disclose with your invention. And really, there's no hiding the ball. You have to bear everything. Handshake with the devil. You tell everything, you get the exclusive period. Now, the bar that you have to cross over is you have to explain to somebody skilled in the art how to make, use, and practice your invention without undue experimentation. So what that means is that somebody skilled in the art. Well, who is that? Well, that's somebody that ought to know how to make and use your invention. You have to explain to them, they read your patent, they go, oh yeah, okay, cool, I can do that. Now, you have to tell them how to do it with enough detail that they can make, use, and practice your invention without undue experimentation. So you don't have to go to the nth degree in your explanation of how your invention works. So for instance, and I'm just flying off the cuff here, if your invention was some sort of a process where you're making something that involved boiling water, saying boiling water, you have to boil the water, that's one of the steps. That's sufficient. You don't have to tell them the exact boiling temperature or the elevation at which you're boiling or whether or not it's Fahrenheit or Celsius. I mean, a little fiddling around is okay. You'll work with your patent attorney, and it's your patent attorney's job to make sure that you have provided enough disclosure information to enable one skilled in the art to make, use, and practice your invention without undue experimentation. That's our job, to make sure that you cross that threshold. And when you're being interviewed by your attorney, make sure that they're drawing all of this information out from you. Let's try the next slide. Oh, sure, what we've been talking about. When you reach that level, clearly you can show you're in possession of the claimed invention. And tradition requires we also indicate the best mode that you're contemplating carrying out the invention by the inventor. What's important in this patent office slide was, and it didn't really come out and say it, is that you've got to be in possession of your invention. It's got to be more than just an idea. So there's two ways to be in possession of your invention. Many inventors have an actual working model of their invention, and they can fiddle with it and show people that, yeah, this works. This is my invention. I have a working model. That's called reduction to practice. However, there's another way to show the world that you are in possession of your claimed invention, and that is a constructive reduction to practice. And constructive reduction to practice occurs on the day you file your patent application with the patent office with enough disclosure to teach one of ordinary skill in the art to how to make, use, and practice your invention without undue experimentation. So the question that's probably running through your mind is, well, I think I have an idea here. Do I have to actually take it so far to have a working model of my invention? Always good if you can do that, but it's not a requirement. Because if you're in possession of your invention, if it's all in your head, that's okay. As long as we, in the patent application, disclose what your invention is, because that proves you're in possession of your invention. So next slide, slide 1 of 2. So what happens is you file your patent application, your real deal one, the non-provisional utility application with the patent office, and we begin this examination process. And the first go around, the examiner looks at your claims and may issue a rejection and or an objection. Objections really have to do with formality, like, hey, you know, there's a typo in here, or you didn't follow all the rules about dotting I's and crossing T's. Easy fixes. The rejection is saying, no, you can't have a patent application because these claims are just not allowable. And they can not be allowable for two problems. First, you may not have gotten into patentable subject matter. That is, maybe the claims that you're trying to get patented merely are an abstract idea. Hopefully your patent attorney has written good claims that you don't have to deal with that problem. Rather, the rejection may be based on prior art. And that is, the examiner has found some sort of a prior art reference, such as a patent or an application in the US or worldwide, that shows you aren't first with your idea. When that happens, they issue an office action. It comes back, says, sorry, you can't have a patent because I think this reference A, this reference B, this reference C tend to show that you're not first with your idea. So we look at it with you, and we need to answer the question, well, you know, maybe the examiner is right. You know, maybe our claims are too broad. Maybe we're trying to get too much. Maybe we don't have the new gee whiz wording into the claim. And in that case, we would amend the claim and then point out to the examiner, hey, we've changed your claim, our claims, and so please reconsider our application. Or it might be that the examiner has made a mistake. Maybe he didn't understand your invention. or the words in the claims that we're using to describe our invention. Maybe they didn't understand what the prior art was actually teaching and disclosing. And so we would have to prepare an argument explaining why we think the examiner made an error in their interpretation of the prior art, and that the rejection was issued in error, in which case they will hopefully reconsider that and go, oh yeah, okay, yeah, now I understand, you're right. You know, that prior art reference doesn't disclose what I thought it was. You're right. Okay, yeah, you guys are different. And then you go down Allowance Boulevard and you get your patent. However, that might not happen. The examiner may dig their feet in and say, I'm sorry, you know, I believe I'm right. I just can't let you have a patent. Well, in that case, we may have to appeal the final decision of the examiner. Or, you know, you may just decide to give up and abandon the effort. It might have to do with finances. It might have to do with really, you're just never going to get a patent because you just aren't first. So it can go one of three ways. Now, this is the U.S. Patent Office's slide from their website. There's a couple things going on in here, though, that this slide illustrates that that I want to chat on for a second. The application is filed at the very beginning. So one of the first costs that you're going to incur is the preparation and filing of the patent application. Provisional or the real deal application, you know, it takes money and time, and they also hold their hands out for money. There's application filing fees. Once examination finally commences and you get that rejection back, then you have to deal with it, and that is going to take a fair amount of attorney time. These are a day and a half jobs. So that could be a couple, $2,000 or $3,000, depending on the complexity of your claims, of your invention, and the complexity of the prior art references. You know, if in one case, maybe the examiner is only using a single reference, and your patent attorney only has to read and understand and analyze one reference, but very often it could be 3, 4, 5, 6, 7, 10 references. Well, you know, this is a lot of work. So much, you know, this is a tennis game. The ball goes back and forth across the net. And each time it goes back and forth across the net, you're going to have to pay your patent attorney to prepare the response back to the office action that the examiner issued. Then hopefully you can work something out. And if you go down Allowance Boulevard to get the patent, that again takes more money. The patent office holds out their hand and says, pay us the issue fees and we'll issue your patent. And then, of course, the attorney it's going to take a little time to do all the documents and do all of that. So there'll be a little bit of a service fee of some sort. And then you get your patent. And then a few years later, the patent office comes back and says, hey, we want our first maintenance fee. And they hold out their hand again. And then I think like 7 or 8 years later, they come back again, hold their hand out again, and they do that 3 times. If you're filing internationally, same thing goes on. The European patent examiner will issue an office action. The European patent attorney and your US patent attorney working together will have to reply to those office actions. And then once you get your European patent allowed, same thing. They hold out their hands for money. And same with Japan and China and Indonesia and Canada and everywhere else you filed internationally. So again, these costs can just geometrically explode on you. at least if you're staying in the United States, I usually tell an applicant, there's no way to predict how much it's going to cost. Sometimes it'll just go through the first time. But what I usually say is kind of get your head in a mindset that it's a little bit like buying a new car. Okay, not a Tesla, but it might be a little bit like buying a Corolla or a Honda two-door or something like that. It could be 7, 10, 12, 15, maybe more $1,000 rather than just the initial patent application filing. So going all the way back to the beginning, when you're trying to figure out what patent attorney you want to work with, you want to ask these questions. Well, how much does an office action response cost to prepare? How do you handle it? Is it flat fee? Is it hourly? What is your fee to pay for the issue fees when we finally get allowance? How much is the appeal process? If we have to go to the appeal process, that's a lot of work. And it costs a lot of money in fees to the patent office. That could be $7,000, $8,000 easily.
Hey, Ray, just a heads up. We're running a little bit behind. I know you have quite a few slides left.
Okay, so let's blast through them. Yeah, next one. I think I finished that one. So we've talked about what the office actions are. And so let's look at the next one. It's all normal part, and we've talked about it. The rejections are a good thing, and we want to work with the patent office. The last thing you want is a patent granted that really wasn't thoroughly examined, because an infringer who is infringing, if they try to invalidate your patent, might try and bring forth a reference to the judge and argue that, hey, you shouldn't, if the examiner would have seen this reference, you would have never gotten the patent in the first place. And if they can convince the judge of that, well, the judge might have to invalidate your patent. So this process of working with the patent office is good. Let's try the next one. So this slide from the patent office delves on how much new do you have to be with your idea. If your idea is novel, then there's no single prior art reference that shows you're not first with your idea. However, you need a little more. You need to be, your invention needs to be non-obvious. So again, back to the very beginning, please bootstrap yourself up and learn about what this examination process is. A lot of great information, and we don't need to really get into it here. It's just, these are things for you to look for and learn about, so that when you get into this patent landscape, you understand what's going to happen. Let's take a look at the next one. So what are prior art references? We've talked about those. They are published before your effective filing date, either the filing date of the provisional or the filing date of your application. That's all they are. Next slide. Typical processing timeline. We've chatted about that. Boy, it gets into the examiner's in basket and it sits there for a little over a year. That's very typical. Very typical. When I first started this, that was more like 2.5 years, not 14 months. The patent office has been working really hard over the last 20 years to cut down this examination time frame now, so that it's typically a couple of years. If it's important for you to get your patent application examined because you want to get your hands on a patent as soon as possible, you can pay for prioritized examination. And that's just a matter of handing over more money to the patent office. And then that way, when your patent application goes into the in basket, you go straight to the head of the line with your examiner. Next slide. So the allowance and issuance is the patent office here is indicating that once you finally get this notice of allowance from the examiner is saying, hey, everything looks good. Give us more money and we'll issue you a patent. And you have your patent. Next slide. And that's the end of their slide presentation. So at this point, I'm open it up to questions.
Hey everyone, I just wanted to say a big thanks to Michelle and Ray for presenting. I just wanted to recognize them first before we jump into a QA session. I know some people may start dropping, but a big thanks to both of you for presenting tonight. We really appreciate it. Lots of really great information. I have a list of questions I will ask, and if anyone else has questions, we will now move to a QA session. But again, on behalf of Win, thank you so much for presenting tonight. And with that, let me jump to the first question with regards to the defendability of, and I think this applies both to trademarks and patents. What is the purpose of applying for a trademark or patent or copyright if you don't necessarily have the resources to defend it? And this is coming from the perspective of small businesses who may be going out there to do this work.
For small businesses, trademarks are worth doing. Whether you defend it, you're going to have less of a need to defend something if you've registered your trademark, as opposed to if you're just using a mark without even checking to see if you can use it. So for the trademarks, it's kind of the opposite. As long as you register, you may not ever have to defend it because the registration serves as notice to the world, or at least the rest of the country. But I think for patents, it's a different story.
And Ray?
It's a tough question because litigation can be hugely expensive. And I don't know much about litigation. My specialty is I'm the patent portal and getting the patents. I do know that if you have a patent and you're being infringed, then of course, you need to engage an attorney to get that cease and desist letter, get them to sit down to the table, and get them to hopefully be rational and reasonable with you. I don't think, for the most part, infringers aren't necessarily bad people that are trying to rip you off, and hopefully everybody can sit down around the table and work something out. That's the first strategy anyone would recommend. But if you have to go litigate, you have to litigate, and hopefully you'll have the resources to be able to do that.
Kind of a follow-up question, I think, to that is, what causes a trademark to be considered abandoned or dead? And I guess to Ray, with respect to copyright, then the question would be, what is the maintenance to kind of upkeep that patent?
So for a trademark to be abandoned means that you haven't finished the application, or you got a refusal and you didn't answer the office action. If you don't answer the office action, your mark will go abandoned. Once it becomes abandoned, there's very little you can do. I mean, if it becomes abandoned and within 2 months you file a request to reinstate it, then you may be able to get it alive again. But usually it's for lack of doing something with the trademark office that you were supposed to do.
Is there any upkeep to the registration?
Yeah, so once you pay your application fee, there's a chance you don't have to pay another penny until the 5th or 6th year after registration. Then there's comes due a statement of use. And that's when you can also become incontestable. And that's another few $100s. It's nothing like patent maintenance fees as far as I understand, but right now for a trademark, it's about, I want to say it's like $300 and some dollars just to keep your trademark alive per class. So, and then the next one's due at 10 years. So you have registration, then you have by the 6th year, by the 10th year, and then every 10 years thereafter. So after that, it's hardly anything. And it can go on forever. And that's the beauty of a trademark as compared to a patent is the trademark can last for hundreds and hundreds of years as long as you keep using it and somebody keeps renewing it.
Ray?
With respect to patents, they have these maintenance fees due at 3.5 years after patent grant, 7.5 years, and 11.5 years. If you qualify for micro entity status, so if you're an individual inventor, those fees are $500, $940, and $1925. If you're a small company, then those fees at 3.5 years are $1,000, 7.5 years, $1,880, and at 11.5 years, $3,850. I don't know why patent offices do this to people, but it's just the way it is. All countries do this. I just did this year's maintenance fees for a client who has applications or patents in France, Germany, and the UK. And that bill from the foreign associate was about $4,500. Every year they do this. So at least the United States isn't having these maintenance fees every year. If they aren't paid, then the patent lapses, much like a trademark.
Jeff kind of asked an interesting question. I think this it pertains to you, Ray. What if a computer is the inventor? So in today's day and age, when we're using maybe AI learning algorithms and things like that, if you are basically just the caretaker who wrote maybe the peripheral code, how would that work? Is there any provisions for that?
I'm not aware that it's ever happened. It will be interesting if it ever happens, but the law is real clear, only people.
And then Grateful Graphics had a question, does a poor man's copyright still work? Mailing your work to yourself via registered mail and not opening it until needed in court.
The reality is that once the thing that you create is completed and readable and seeable and discernible, whether you mail it to yourself or not, or you just put a date on it and stick it in your safe or stick it wherever you want, you can do that. It's the same thing. I know that people used to do that. I don't know that anybody still does that, but the thing about that mailing thing is that it allowed you to have a date. That's what it did. And that's why you couldn't open it, because if the date stamp was on there from the post office, then that was the date that they used as your creation date. I think there's a lot of different ways to do that these days.
And Deborah had a question. I don't think she's with us anymore, but I think the question is still practical. How do I best protect my intellectual property, specifically curriculum development and personal and professional development exercises? I think this applies to kind of IP in general. So for any of us small businesses that are creating IP, maybe that doesn't fall into the category of a patent. Really, what can we best do to protect that?
It depends on what she really means by that. I saw that question pop up on the screen too. So there's 4 different. Go ahead, Ray.
Okay, yeah, this is a sticky problem, and I'm actually this week working on that exact problem, the curriculum problem. The curriculum is an abstract idea. It just is. It's a business method. You cannot get patent protection for that sort of subject matter. So what we're doing is we're figuring out how to have a computer system implement, manage, track, do the curriculum process. And we're going to try and shoehorn in that way and at least get some level of protection, if that makes sense.
Michelle, you were saying?
Well, I want to take it in a different way, and maybe I don't know exactly what you mean by a curriculum. Why don't we just leave Ray's answer? I was going to go a totally different way with that.
Well, let me ask it from a broader perspective. Let's say I run an engineering company, and if I develop some item, it's not necessarily patentable, but there's some IP value in what I developed. Maybe some source code, maybe some designs, and it's not something we want to fully disclose in the form of a patent. What's our best course of action to protect that intellectual property?
I think copyright takes care of a lot of that. That's where I was going to go, down the copyright track. That
Okay.
takes care of a lot of that.
And what do you have to disclose to get? Again, this comes back, like I asked this question earlier, of common law. If I write a line of code, to a certain
If you're a lot of
extent,
code and you don't want to disclose it, then don't file anything for it. What I would do is keep it. What neither of us talked about was kind of the fourth area of IP, which is trade secrets. Trade secrets are those things like algorithms, like Google and every other computer company and Instagram, Facebook. They don't ever tell anybody what those algorithms are, right? And they change them pretty often. Those are kept as trade secrets, and there's a whole trade secrets law. And if you keep it as a trade secret, you're probably better protected than anywhere else. But you got to have everybody's got to have an NDA. Everybody who works for you has to know that it's trade secret and they can't talk about it ever, even after they leave the company. It's that kind of thing. So if it's really something you don't want to disclose, maybe you just don't.
Okay, good. Great advice for sure. I think that is it for questions. Do you guys have any closing remarks? And if someone wants to get a hold of you, what is the best way for them to reach out to you guys?
I'm available at bellwetherlegal.com if anybody needs any trademark help with anything or any copyright help with anything. I think there was a link in the invitation to my website. So happy to help if anybody needs anything. Just give me a shout.
And likewise for me, at More IP, just go over to the website and you can find us and find me and drop me an email. And if you'd like to chat, happy to help.
All right. Hey, thanks so much to both of you for presenting tonight. We really appreciate it. And thanks for everyone who joined us on tonight's Pub Talk. And we will see you next month for our next Pub Talk.
Okay. Thanks, everybody.
Thank you very much, everyone. Have a good night.
Thanks.